Welcome. This is the Domain Name Law Show. We're here every Tuesday, noon Pacific, 3 p.m. Eastern. This is where we discuss domain name legal issues. We review recent UDRP decisions, which are domain disputes. And sometimes we'll talk about just general industry news, come up with other topics, and so on. There's three hosts to this show. My name is Todd Ryan. My co-hosts are David Michaels and Jeff Neuman. I'd like to say hello to those guys before we get rolling. Hey, David, how's everything going today?
All right. How's my audio?
Yeah, that sounds good. Yeah, Jeff, busy. Well, Jeff's in New York. He's got some depositions this week, big one tomorrow. Working on some things. I'm working on pretty much everything with him now. Go to JJN Solutions.com if you need some legal help. You just want to see my picture, see what Jeff and I are doing. But you can certainly, if you have a domain dispute, you have any issues with companies in this space or with individuals you're transacting with, or maybe you just need some help with some agreements or whatever. Domain name law is Jeff's specialty. So check us out, jjnsolutions.com. Well, today we have a pretty big show, and I mean big, well, some interesting cases. David, the first thing I wanted to cover, and anybody wants to check out our show outline, they can certainly do it, dnlshow.com/outline. And the first piece of news on this outline was, okay, so the Supreme Court ruled that it was basically a ruling that the DMCA, those takedowns, it's when you contact a host. This is normally how it works. You contact a hosting company and you say, hey, this website has copywriting materials, infringing materials on there. It's not trademark stuff. It's copyright usually. That's what it is for a DMCA takedown. So you might say, hey, they're using our song, or they copied our whole website. They copied all of our content and they're putting it on their site, acting like it's theirs. So then the company files what they call a DMCA takedown with a hosting company, and then the hosting company acts on it. And hosting companies were basically also service providers, like I don't know who service provides, AT&T does, but Spectrum, places like this, they would not be held responsible for content that they hosted, or that they hosted through their systems, if they responded quickly to these DMCA takedowns. So that was like part of the deal. As long as you guys, respond quickly to takedown notices from copyright holders, then that's part of the deal. Then you're not responsible for content. And of course, there can be some, really bad content, abusive content, along with, impersonation, but basically copyright infringement. Okay, so there was an article by Phil Corwin, who I think he was the one who helped start the ICA back in the day. But anyway, well known in ICANN circles, but he went over to VeriSign, was working for them for I think 7 or 8 years, but he just wrote an article and said, hey, I'm no longer at VeriSign. I'm back to my independent thing. He's like a leader in this area, I guess, domain name law and policy and so on. But now he's like back to handling things himself, meaning his own firm, and he's writing articles again. And his first article was this no safe harbor Supreme Court of the U.S. Scuttles the DMCA. So David, I don't know if, did you have a chance to read it and summarize? I tried to for the crowd, but summarize what he means by the Supreme Court has scuttled the DMCA.
Yeah, so Phil is actually older than he looks in the photo in that article. But the difference is now, so registrars won't necessarily be incentivized to suspend a domain name if it's alleged that it has some copyright infringement material on there, or otherwise do a takedown. Like, it's not their job. If this registrar is, a normal registrar, they're not hosting like a site that just like Pirate Bay or like that, then there's nothing that they have to do. It's not intended as a service to be used for infringement. So if they're not intending it to be used that way, then they have no real incentive now to take it down, which is, I think, fair, because it was a huge burden if you ask registrars and host providers to take down these sites and like look at these DMCA things. I don't know how it's going to affect YouTube. That's a different story. But as far as registrars now, it's probably a lot easier. What do
Yeah,
you think?
no, it was the big responsibility, like you said, for registrars, hosting companies. They get a ton of requests. There's people all the time saying, "Hey, you know, similar." A lot of people may not be familiar with a DMCA takedown as much as somebody using a site like eBay, and you say, "Hey, this person is, that's a photo that I took, and they're infringing on my copyright." So they contact. There's a division in eBay, Vero, Vero, but you'd saying, "Hey, take down that listing. These people are infringing on my copyright. We own that photo," for example. Okay, so uh, they are responsible. eBay was responsible for taking down the infringing material. In website equivalence, yeah, if somebody's like, "Hey, they've copied our website, they have it over at another website, they're impersonating us, but more so, they've infringed on our copyright on all of our material." So that copyright owner contacts, as I mentioned this already, contact the fucking host, excuse my language, and says, "Hey, take down this website." And then, of course, it's a headache, but the hosting company is like, "That's part of the deal we have to indemnify us or make us not liable for all this content that we're hosting," because people will host, like I said, abusive content, illegal content, and the hosting company wants to make sure we're not responsible for it. We provide, hosting services, but people will upload all sorts of, materials, and we don't want to be held responsible for it, especially when it's copyrighted materials by somebody else. We don't want to be sued by that copyright owner. So the deal was, you guys acknowledge these takedown notices, and that's sort of like the deal. Well, now the Supreme Court says, "Listen, you guys don't have to worry about these takedown notices." In a nutshell, they said, if your hosting company wasn't established to really host, this infringing material, sort of like how Napster was created for people to upload music that in most cases they didn't own the copyright to. It was just other users upload. So what the Supreme Court's saying is, as long as this hosting company or the service provider wasn't created to host infringing material, or makes it attractive, or rewards the posting of infringing material, then they have nothing to worry about. So basically, now the hosting company's like, "Yeah, so all we have to do is show that we weren't established to host this type of material, and we're not rewarding people for doing it." Well, that's a whole different standard. And they're like, "So now we don't have to worry about all these takedown notices." So David Sand's right. Yeah, it sounds like now you're going to get people that are posting all sorts of infringing material, and then as a copyright owner, you're going to say, "Hey, take this down to the host," and the host is like, "Yeah, we used to jump on that stuff. Now we may acknowledge it, we may take it down, but we're just now not obligated to." And it's a pretty big deal. I mean, so copyright owners must be, I don't know, furious. Most of them, I don't know, I guess, do they know about it yet? Do they know about this ruling? So that's I guess, let's see.
Yeah, I think there's just a small caveat there. Like, if there is like a website being imitated, it's probably a phishing site, and they still have obligations under ICANN rules to suspend the domain name if that can be proven. It's called DNS abuse. That's the only situation that I can see where copyright intersects DNS abuse.
Yep. No, good point. Hey, got Harvey joining us on stage. Harvey, what comment or question did you have? Nice to see you. You're on mute there. I don't know, maybe you came up on accident.
Yeah, I think Harvey pressed it by accident.
Okay. I'm going to say that's unusual. Harvey trying to come in and cause some problems. He's like, yeah, is this a mosh pit? I'm here now.
Let's talk about the next case. It's actually
Okay.
pretty interesting.
Yeah, the
about
Vitali or Vin Italy case. Is that the one you were mentioning?
Yeah,
Go ahead.
absolutely. Okay, so Vin or Vinny actually is Latin for wine. And, it's interesting that the company in Italy decided to market something in the US or somebody in the US without first registering a domain name on their own or getting a trademark until 2025. But the agreement they had is kind of murky, and that basically, like the guy who registered the domain name was actually a partner for marketing, so didn't actually have any type of, you know, some fiduciary obligation to the complainant. And I think that's the reason why they're able to continue. There is litigation going on now. It's been filed in federal court. So this domain name case was dismissed, but I don't even know if they're going to get the trademark. Well, the trademark is Vin Italy, one word. It's a portmanteau. It's kind of like Vin Italy, Vinny Italy, two words. If it was applied for as two words, it would be rejected because it's merely descriptive. Because hey, doctrine of foreign equivalence, wine Italy, everybody knows what that is. So, anyways, we'll see what happens in the lawsuit. But for now, that's all it is. It really wasn't a domain dispute. It was
Yep.
more of a partnership
Yeah,
dispute.
the domain David's talking about is VINITALYUSA.com. So this company, this person registered this domain name was, before they even entered into this joint venture with this company. And so they were going to work together. The relationship falls apart, and then one side says, "Hey, we have rights to that name. We were actually the company that was going to use this. You were just a registrant." Bottom line is, this is not uncommon. There was no bad faith registration, but yet now the parties involved aren't getting along, and working on a case like this right now, where it really is. If there is an issue, it would be a trademark infringement issue for a court to decide. Has nothing to do with, a cyber squatting UDRP type complaint. But many times, it's expensive to file a federal lawsuit to file a trademark infringement case. So, why not? I mean, when I say why not, companies are doing it. I'm seeing it more frequently. Just spend $1,500, sometimes like $1,300 at the forum to just file the case and see if, who knows, they may not answer, you may win. But anyway, there was an article in Domain Gang that got my attention, so I want to give them credit. If you look at our outline at dnlshow.com/outline, you'll see that was a link, to a Domain Gang article. That's not one of our first cases, but we're going to get to our cases right now. Let me look at the outline. Of course, I have on there, and I already mentioned, if you have any legal issues, definitely reach out to us, JJN Solutions. But also, it's really heating up with the gTLD application process. We're overloaded, and it's fantastic time. The window opens April 30th. I will say, if anybody's listening on replay, it's not too late at all to prepare your application and submit it. The window is open April 30th to August 12th. If you submit your application May 2nd or you submit it August 2nd, there's no line. They all get accepted, and they're all going to get reviewed at the same time, but you don't necessarily get reviewed sooner by submitting your application sooner. So the point is, this window is really just a window for all the applications to be accepted, and then ICANN will go through and decide, okay, was yours a brand application, a community application, a true generic gTLD application, and then they will start reviewing. But so still plenty of time, but it's really time to get your ducks in a row and start understanding everything you're going to have to provide to ICANN if you want to apply for gTLD, and the expenses involved. Make sure you're budgeted correctly, because it's not an inexpensive process. Okay, so if you're looking at our outline, you can see our first case today is CAPTE.com. So it's a 5-letter domain name. Interesting case, because this was a domain that GoDaddy acquired from Uniregistry. They when they bought the portfolio back in 2020, this came along. Basically, when they bought Uniregistry, the registrar, they got all their domains too, and this was one of them. And GoDaddy brings it up in their defense in this case, because the complainant is a company out of the Netherlands, CAPTE, which is the domain name, Capti Holding, and in the Netherlands, and they were represented by some lawyer on the inside. But GoDaddy NameFind represented by friend of the show, Gerald Levine Samuel here in the U.S. So we'll talk about the defense. But David, what was the complainant's case here? Why did they feel that they should? I mean, just go into a little bit the complainant's case, and then how the respondents' attorneys replied.
So the complainants, they registered their company, I believe it was in 2017, and they started to do business. They went to some trade shows in Europe, and they even had one contract signed in 2018. But it doesn't really show that they had any type of notoriety anywhere in North America or worldwide before. Actually, let me clear my throat. Before GoDaddy acquired the NameFind portfolio, or the portfolio from Uniregistry in 2020. So one of the big issues that I didn't like was David Bernstein found that GoDaddy did not demonstrate legitimate interests, because they couldn't justify as to why this particular 5-letter domain name was registered when it was. Why was it acquired by GoDaddy? What was the value in their mind? What was the reasoning? And Gerald Levine said it doesn't matter. It's irrelevant. So, I checked. What does capte mean? It means capture in French. There's a lot of companies registered throughout Europe and South America with the name capte. And so this company that's the complainant is not unique in the world. And I think that was a major issue. And you know what? They couldn't prove that they had trademark rights as of 2020. What else did you find in this case?
Well, okay, so the domain, once again, CAPTE.com, owned by NameFind Portfolio. They bought it when they bought Uniregistry, and the defense was, I mean, the complaint basically just said, hey, they picked up this name. Why did they pick it up? They don't have, it matches our trademark. They don't have any legitimate use for it. I mean, other than they bought it up, it's been passive holding. And we consider that, a bad faith registration. It wasn't, I was going to say the response is what made clear. The complaint says what they normally say. They're not known by this name. They're not using it in a bona fide way. So we assume that their acquisition in 2020 was in bad faith, and it's being used in bad faith. Well, the response, the strong part of the response was this: you guys didn't really have a registration until 2025 on CAPTE. So one, even this acquisition date of 2020 precedes your trademark registration. But we're focusing on even the 2004, I believe it was 2004 real registration date, because GoDaddy was saying, Namefind was saying, we bought this company, so we're buying the rights to all their assets, and that includes their, you know, their original registration to this name and their reason for their original, they originally registered it. It doesn't matter why they thought it was valuable. They thought it was valuable because it was a short name. When we picked it up in 2020 as part of a portfolio, we just, assumed all rights that they had, and that was their position. And there was something else I was going to say about. Well, I think I already said it about no matter whether it was the registration date or the acquisition date, this preceded your trademark. Oh, and Jerry did also say, you guys you're small in a niche business. No one knew of was aware of you when they acquired it anyway. So there were several reasons why you guys shouldn't have rights to this, name. It was ruled, the complaint was denied, but the respondents, the domain owners, wanted a reverse domain name hijacking. The panel said, no, we're not going to rule that there was an abuse of the system by doing this. But what you mentioned about David Bernstein, yeah, he just had to say, even though he did agree with the decision to deny the complaint, he just had to say, do you really have legitimate interest? He just wanted to say to GoDaddy, do you really have legitimate interest buying this name when you can't explain why you picked it up? And because he didn't buy the explanation that, it was part of a portfolio, so you're just picking up all their assets. He wanted a specific, why did you buy it? What were you going to do with it? And so on. And sort of, I don't know, it was sort of weird because he did agree with the decision, but he just felt like he wanted to know why the respondents, felt that they had, legitimate rights to this name. Just wasn't convinced. But anyway, they were successful, David, right? This was a complaint denied, but you don't see sort of a dissent on part of the
decision. It should have been RDNH.
Yeah.
There was no real basis for it, like for the complaint. Like they're just a small fish in the big world. And in the Netherlands, why would GoDaddy acquiring that portfolio in 2020 pick it specifically for that name? And have the complainant in mind? Like, no, they weren't on anybody's radar. I think that's the biggest issue.
Yeah.
But it was kind of clouded, like in the ICA blog post that came out today, they kind of obscured that issue, like the way they described the holding. Anyway, I think things need to be more clear.
Well, you think that a straightforward answer like we have domains, we buy names to resell them. We're a big company and we have a marketplace. But anyway, whether it was a big company like GoDaddy or an individual, why couldn't the reply simply be, we bought this name as part of a portfolio. We're a domain name investment group, or we're a domain investor, and that's a legitimate business. Is anybody, I thought some panelists all agree on that. This is a legitimate business. We didn't reach out to try to target this one company. They're small anyway. Why? It seemed to me like this would be an easy decision, but you can't just say, well, we're a domain investor. GoDaddy started bringing up, these attorneys, and you need them, bring up all sorts of different reasons why. We have rights because of this. We acquired the company along with their portfolio. So the original date means something because when we were acquiring all these assets, like the registrar and some of their other assets, from dashboards to UIs and UXs and bullshit. So, I don't know why the defense, the respondent, can't just be clear. I'm a domain investor. I bought it for this reason. I never did target them. I bought it to resell it. And I think they even had a reasonable.
I think the real answer should be, it's a dictionary word in 3 languages. It's the kind of name that investors by. That's the reason. It's just plain simple. It's a dictionary word, one word. And it's 5 letters. It's easy to spell and easy to pronounce. What else do you need? That's the best type of name. And it means something. It means capture, which is kind of descriptive of their business in terms of tracking.
Yeah. I mean, okay, so they did win. I mean, GoDaddy got to keep the name, but it was a 3-member panel. We talk about that, cost you more money when it's a 3-member panel, but you certainly need them in cases that you have. But basically, it's always best to have a 3-member panel as a domain name investor. Okay. Hey, Brad, nice to see you. What question or comment did you have? You're on mute. It's like I'm talking to somebody over.
Yeah, maybe just been press the button by accident.
Maybe. I don't know. He's pretty slick. He knows. He always has a comment. Brad, are you there? Okay.
I'm sorry.
Go ahead.
Hi. Thank you,
Yeah.
Todd. Thank you, David. Did you say that one of the panelists questioned why, if what was your legitimate interest? And when you said that, I was thinking that perhaps the panelist was kind of not necessarily, he was digging on Gerald Levine. You know what I mean? Like from some past thing, he knows that Levine is a, big time IP attorney, and Bernstein, if that was one of the panelists, was questioning kind of like an inappropriate question, right? It's kind of inappropriate to say, okay, well, what was your, even though I agree with you, I want to know what you thought about it, or something like that. He was wanting an extra explanation. Am I reading that wrong?
Yeah, well, I think I've read it the same way. I mean, sort of, I think, I don't know. I'm going to maybe talk with Jerry today and ask him, yeah, how did they take this? Because it's like, David Bernstein was he was the key speaker at last year. Jerry has an annual, it's sort of like an annual, I don't know what you call it, meetup where basically he'll showcase a certain domain name lawyer who's usually also a panelist and talks about UDRPs, where it's headed, decisions, trends that we're seeing. And David Bernstein was the speaker last year, and it's Jerry's, called who comes on there. So they're friends, they're colleagues and friends, and know each other. But yes, I took it as basically what he said was the respondent, and he's meaning you're right, their counsel has not offered any credible explanation for why its predecessor in interest registered the disputed domain name. So just because you're saying you picked it up from them, all right, well, why did they get it? Why it was acquired and re-registered, and then, why did you pick it up in 2020 other than to, he says, other than to baldly state that it was registered in connection with a business of investing in domain names. Well, that seems legitimate, legitimate enough to me. But yeah, he was like, I need to know more. And yeah, I forget how. I thought I saw a response
Yeah,
somewhere.
I mean, it shouldn't matter at all on any level.
It says, although the registration of domain names for investment, this was what Bernstein wrote, and resale can constitute a legitimate interest that is typically an accepted rationale when the domain names correspond to acronyms, dictionary words, common phrases. So that was always the key when I say, hey, don't panelists think domain investing is legitimate? Yeah, if it's a 3-letter, and that's only some of them. Some of them get mad at, or a dictionary word. They want to make sure it's like, all right, is it a 3-letter dictionary word? As we know, like a common phrase. But soon as it is a brandable or like a created word, then they want to know, listen, it better be almost real unique and catchy. If it's made up, it's almost like that doesn't always make it legitimate. So yeah, he was wanting to know more from the respondent. Why this name? Why are you saying this is okay? But anyway, David mentioned that it is related to, there are, I think, a French word, but has an accent.
It's French, Spanish, and Portuguese for the word capture.
Yeah. Okay. But anyway, I think what'll clear up some things, or not clear up, but it'll think, geez, this next case seemed like it would be perfect for a panelist to understand that it is a generic word, or it's a dictionary word, and you can see why a domain investor would want to get it. So that first case, capte.com, was owned by GoDaddy. They got to keep the name complaint denied. The second case is report.ge. So report.ge. GE is the country code for Georgia, not the state. Okay, it's a little country over there. But I think they have their own language, but they're right next to Russia, so I know there's a lot of Russia. Okay, so anyway, this complainant in this case was Report News Agency out of Georgia. They had the name, they forgot to renew it, and of course it was picked up by a domain investor, and it was a domain investor out of Bulgaria, SEO.domains. But the bottom line is, I have to push my dog away. Max, get out of here. So bottom line, this Bulgarian domain investor caught it on the drop, and that's the big deal. So this company's like, hey, we're known. We have the trademark in Georgia. We're known as Report News Agency. And because it's got the .ge extension, we believe we have rights to this, even though it is, a word, a dictionary word, report.ge. And you would think, all right, well, you better, I don't know, I would immediately think you need to show that this guy bought it, immediately contacted you, said, I want $1 million. I bought it because of you and your trademark, so on. That's the only way I think this complainant would have a case. That really wasn't true in this instance. And I'll say, okay, so this news agency out of Georgia said, hey, we offered, we know this guy has a bunch of domain names, and we see that he owns SEO.domains. We offered him $200 anonymously for the name. The respondent came back and said, I want $7,500. And then he didn't hear from the complainant anymore. Finally, he reached out to the complainant again and said, I'll take $4,500. And the complainant said, we'll give you $500. The respondent, the domain owner, said no. And then to sum this up, the complainant had their head of tech said, hey, contact, said, we own this name for several years. We forgot to renew it. Can you transfer it to us, out of goodwill, or just, be kind? And they said, no, it's $7,500. Okay. So then they said, well, now we're filing this, we're going to file this UDRP. And I will, before I throw it to David, say, when you file a UDRP for a .ge name, which is still handled by WIPO, but there's different rules. It's like a .us. It's, or, okay, either you can, if it's registered in bad faith or used in bad faith, it can, you can rule to transfer the name if you feel like it was one of those. It doesn't have to be both. So that was very important in this case. David, report.ge, the news agency out of Georgia, files the complaint. The Bulgaria domain investor responded. What do you think? How do you think the domain owner, the domain registrant, could have made a stronger case to keep this thing?
You should have mentioned anything about SEO metrics. It's not actually that great a name. Sure, it has a DR of 44, but I looked at the site history on archive, and it's nothing special. And it's in Georgian, a special script. It's not Cyrillic, it's something totally different. And anyways, GE, I never actually knew about that CCTLD, but that would be such a great CCTLD for a lot of businesses around the world. Anyway, all you had to do is just go to name bio and type in report exact match and look at all the sales for the word report. And there are like report.co.uk sold for $12,750. So that's even more than the $7,500 he was asking for. And that was more than a decade ago. I think it was 2012. So a one word dot ccTLD name, like report, should be worth at least 10,000, if not more. The fact that he was asking only 7,500 was, I don't think a lot, but I think the panelists took it the wrong way because his respondent started talking right away. It's like his first paragraph saying he acquired it because through an automated system because it monitors names for um, SEO metrics without actually looking at the name. All they look at is the backlink count. Sure, that's a strategy, but this particular name has more value than its metrics, and he should have responded that way.
Yeah. So this
What do
name
you
was
think?
transferred
How would
away.
you
The
have
domain
responded?
owner lost it. And David, you bring up, so what happened here? You think this Andrew Lothian, we've talked about, a lot. He's a panelist that reviews a lot of cases. He basically said, well, it only has to be bad faith registered. Or used in bad faith. So I don't know if it was registered in bad faith on that exact moment, but apparently, um, it was. Now he's deciding that it was because he's like the guy's using it in bad faith by marketing that its value stems from the past traffic that was, derived from this other person's trademark. So Andrew Lothian was saying you're expressing the value of this name, that is, like I said, directly derived from their mark, that the traffic they used to have on it, it dropped, you picked it up. When you're explaining to people why this name is valuable, you're basically explaining it in a fashion that is targeting. That's how Andrew Lothian took it, and he said that's why he transferred it, because he transferred the name because he didn't like how the guy was really marketing, and basically when he's doing a sales pitch to say, because Andrew Lothian knows selling domain names is legitimate, but because this was a country code and he only had to show that, was one or the other, was it registered in bad faith? I think he might have found that it was registered in bad faith when, when he sees how the guy's acting after he got it. He got it and he said, hey, like David mentioned, I got it because of the SEO strength of this thing. And if it wasn't for that, would he have still picked up this name? Well, that would have been something he would want to have included in his case to say, hey, I picked up report for several reasons. It can't change the fact that somebody owned it before and there's traffic that's coming in from their the people looking for their website. They had it for 5 years or 10 years. This is something that I've discussed with some attorneys and some panelists, that why should a new owner of a domain name, you know, he should be allowed to benefit from existing traffic. Why is it wrong of him to go, hey, many times the guys will pick up a name with a lot of traffic, then they point it to a gambling site or a porn site, and then the original registrant says, look what they're doing. They're taking our traffic and now they're redirecting it to something nefarious. So you can't point it to something similar because now you're, basically using the traffic to send to a competitor or PPC links. You can't send it to porn or to fucking gambling because they consider sometimes illegitimate. So you pick up a name and it's got traffic. What are you supposed to do? Put out the traffic like a cigarette in an ashtray? You should be allowed to go, I can't help it. There's traffic coming in on it. I'm not, my intention was not to buy it. Yeah, go ahead. Well, yeah, David, I knew you were going to say something, but that's like saying, anyway. So you could say that really about any domain and almost any domain investor. But I was going to say, if you're doing a report, Brad, on um, there's nothing better than report dot I think a country code. Now you can report on that whole country. We know there's news. Why would one person have the right? And you said he's targeting. Would this guy? We don't know. I don't know if he picked it up for $200, if he picked it up for 2,000. But would he have bought the name report dot GE if it hadn't had, say, if it was just owned by another investor, never developed out? I'm guessing that domain investors, especially, and there is a couple people or a gentleman I know that's in that area that has a portfolio of a few 100,000 names. So I'm assuming that's who it is. Big domain investor, has large portfolio. Quite a bit of the portfolio does consist of names that he buys because they formerly had traffic, were formerly developed out. It's just the weirdest thing. That's what domain investors do. We like names that are registered in several extensions. We like names that are not only registered in several extensions, but many of those extensions are developed out. And we also like to know, hey, this name was once developed out. So I don't believe that he was targeting. He sold iReport, I believe. Yeah, I think he sold iReport. Wasn't it I something? Yeah, Brad, his defense, you're right, gave the panelist a little window to say, were you targeting? Now you got me thinking you were targeting. I mean, it seemed like he would have 5 or 6 other defenses that would be suitable. I mean, use them in combination even, but he focused on the one area that appeared that he was, knew of the original registrant, picked it up because of the original registrant, priced it because of the original registrant, promoted it, because, using info because of the, so all things were. Well, before we get to our last case, Ace joined us on stage. Thanks for jumping up here, Ace. What question or comment did you have? Yeah, sound clear. David, I know you might want to chime in here. Go ahead. Yeah, and yeah, well, before we get right to it, but Ace, it is important, and it's I don't say a small piece. It can end up playing a big piece. Working on a case now where disclaimers on a website are very important, and it's not just. It just depends on what you're disclaiming, and you want to be clear. It's always good you're clear on ownership, any relationships, no relationships, and you don't have to make your case on your website in a disclaimer, but many times, that's part of a UDRP. Why did you pick this name? So sometimes people might have a name on a site, and it's not wrong to mention that it's their daughter's name. Or my point is, verbiage on website is important, and disclaimers, and then notes, on these footers can certainly help out to show that your intention was never to confuse people. Okay, this next case, open dot space, pretty interesting name. I mean, open space. Okay, so this company, what was the name of it? It's called Kratos, Kratos, Kratos Defense and Security Solutions was the complainant, and they have a Kratos open space, say, product. And it's when I say product, it's, what did I have in my notes here? It was they do something that says they're both out of California, them, and then this Martin McCormick, who's the respondent, and the respondent did have something similar on his site. Basically, the complainant, leader in the design and development of communications technology, satellite, space, and aerospace goods and services within the military and defense industry. All right, well, the person who registered the name put in the thing open space, and talked about outer space. So you can, this wasn't, a guy who registered it and said, hey, I'm offering cabinets, something completely different. So it was a little bit, I would say related. They're both talking about, outer space, space, satellites, so on. Okay, so this respondent said, while the name open space is similar to their, the complainant's open space mark, these terms are so generic, open and space, and then together, they're used a lot that, basically that was his main defense, that this is just generic. It didn't register it to target, so he wasn't using it in bad faith. And he said, I'm not a defense contractor, and I don't sell, enterprise satellite tracking software, anything that is even similar to the respondent, even though I mentioned they do, we're mentioning outer space in their website. So the respondent, said that, they've been talking with this complainant about working out a deal with them. So he just felt like, hey, we weren't infringing. We weren't doing anything wrong. We've been talking with this company about maybe they want to pick up the name from us, but we certainly don't want them to be able to, take it away from us just by filing a complaint. David, take it from here. What did you see? And then give the decision on this and whether or not there was any, RDNH or anything in addition to just a decision. Jeff's not here, so he didn't care. Um, yeah. No, I was going to say, yeah, I think exactly that. I think this company, they're did try to bully. They know open dot space is generic, and did they panel was brought in bad faith and does constitute. So they did. I didn't look too much into why the panelist did feel that they abused the system, by filing this. So the panelists did agree that it was reverse domain name hijacking, that the complainant didn't really have a right to it, should have known that. And I believe it was, yeah, because they were represented by a pretty big law firm here in California. So, but we're noticing. Right. And that's why you think, why would they think they have the rights to it? Well, because, yeah, I mean, as us domain investors, that's exactly how we would look at it. Like, okay, so like I said, the name, their trademark included Cractos open space, and then what they say when you say we have a trademark, then you say this domain name has includes part of our mark, and that's how they, basically that's how they had standing to, even continue. I was gonna, this David Kreider, I've this panelist David Kreider, he made a decision that was really, I think it wasn't a great decision. I can't remember the name from a few weeks ago, but since then we've seen two decisions. This one, he said, okay, this company, I will say it's confusingly similar to your trademark, and that was a stretch. But he said, yeah, you weren't successful in showing this domain owner doesn't have legitimate rights to it or registered it in bad faith. So, and considering you had counsel, I think you abused the system. So, once again, ruled RDNH along with the denial. But there's no teeth in a RDNH, meaning there's no penalty. So I can tell you, this law firm is like, okay, what does that mean? Probably they don't even know. I'm seeing some complaints come in, people reaching out to Jeff and I at at the law firm saying, here's a complaint I received, and big firms filing complaints and just making statements like we see, making statements without following up with evidence, and really just not, maybe they're smart attorneys in other fields, but when it comes to domain name law and just taking the UDRP for granted, they think they can just file. They probably hear that in many cases the respondents don't respond, and it's almost like they say this person's not known by that name, we didn't give them rights, and we reached out to them and they wanted us to pay more than their registration cost. And if you don't respond to it as the domain owner, sometimes it gets transferred away from you. We're seeing it less and less, but basically I was just getting at, there's a lot of attorneys that make statements in their complaints, don't provide any evidence, and if you're not there to answer, sometimes a panelist will basically not require them to have evidence. So just take their statement at their word, and they shouldn't do it no matter even if there's a response or not. But in this case, this panelist made a good decision. It's right, and it's not a big fee, but you could get a panelist. There's a few that are really brand centric, meaning they're so used to representing brands that they're like, hey, he better have a good defense. Why would he get this? And if it's even anything close to the trademark, or if we believe that they were aware of this mark, sometimes brand owners will think non-famous marks are famous, and I bring this up to panelists all the time, and attorney or brand attorneys, they think, well, we were well known. You're not. There's very few companies that are, like I said, world known to everyone around the world. Very, very few. Most companies are just, known geographically, and then only in certain sectors. And there's a lot of folks, anyway, there's a lot of companies with same names coexisting out there, but brand attorneys always think our mark is more well known than than it really is, and they'll say that, and you need to provide. I'm dealing with some companies now who say not only they'll say we have a common law mark, and they need to show a lot of evidence, not just here's our corporate charter, or here's our DBA, or here's our Facebook page. You need to really show that you're doing business, you're conducting business under that name if you're saying we have a trademark. But if you're saying, a common law mark, but if you're saying that you're well known, then you need to show we were on 60 Minutes. We're a public company, and when we offered our second round, this is how many investors. You need to really show stuff that if you're saying you have if you're saying you're a well-known mark, and there's ways to do it, but most of the time the companies don't have the evidence to show it. All right, we're going to finish it up for today. Got plenty of things to do. I want to thank everybody for sticking around. Next week it will be. I think. Well, you know what? I think Jeff's going to be in London, and next Tuesday. I think I'm going to be, I'm going to be here because I'm flying out right after next week's show to go to the Dominion conference. So that's right. I think I booked my flight after the show. So David and I will be here next week. I know Jeff's going to be at contracted parties in London, so he probably won't be here. But we'll put together, David, let's come up with, you and I'll decide on 3 cases that I think can really help, bring some insight to domain investors. It'll be us next week. We'll try to come up with some cases that can say, here's some things as a domain investor you want to avoid or be aware of, or here's a good response that you can use as a template, because domain investing is legitimate. So I'll look for a specific case next week that shows someone using a domain investing defense and it being successful, and something that maybe any of us as a domain investor could use if you're not able to afford an attorney to help you, respond to your UDRP. It is important to, get some help. But, sometimes we have these names that just aren't worth, trying to sell them for a couple grand. You certainly don't want to spend more than that to defend it in a UDRP, but believe it. If you're a domain investor, it's going to come around sometime. You'll get one of these complaints. Just don't be nervous about it. Just respond to it and do your best. But all right, thanks for being here. Once again, on Thursday, Josh and I, we were talking. We got plenty of things to discuss this Thursday. That's on the DNX show, 10 a.m. Pacific, 1 p.m. Eastern. So join me and Josh on Thursday. We'll see you next week here on the Domain Name Law Show. Have a great rest of your day wherever you're at. Take care.